Children, Families and Youth for PICUM, and I'll just quickly explain. I'm sitting in a very brightly lit room, so that's why you won't see my image move.
Hi there. I will also just quickly say hello and stop the camera. Thanks for joining, everybody. I'm based in Brussels. I'm a lawyer here, and I've been working in this field and looking at return issues for quite a number of years. So it's great to get the opportunity to talk together about this today.
Yes, and as Katarina said, you cannot, unfortunately, unmute yourself, but do use the chat box in case you have questions during our presentation, and then we can address them at the end of the presentation. So just to start, today it's Rebecca and I from Child Circle and PICUM, but of course the work we're talking about today frames within a much broader network and in a broader collaboration between organizations. So a quick word on the Initiative for Children in Migration. It's a regional, so EU, regional informal or let's say well, informal is fine, network of organizations that work on children in migration, but it's a very vast array of thematics or topics the different members of the initiative work on. So some work specifically on, let's say, borders, others work on child protection, other works on education. So it's quite a broad range. And within that group, of course, there is a smaller group of people and organizations who have been working specifically on durable solutions, and including that, how child rights compliant returns, are they possible, and if so, how? So going to the next slide. What we will look at together today, these are not, let's say, the titles of the different slides, but these are the different topics we're going to look at. It's, of course, what's at stake, then why EU law and policy matters for both children in migration and durable solutions, and what that framework looks like today. How a guidance document and a policy paper, which are two resources we are going to talk about today, came to be, and what do they contain. And important in that framework is, of course, the aspect of terminology, because as you might have noticed in your own work or seen, is that terminology is very important, and we do not always understand the same things under the same concept. Then we'll also look at the durable solutions procedure that is developed within the guidance, and then, of course, at the end, how these resources and how this work can support your advocacy. So, durable solutions for children in migration, what's at stake? It's maybe a first question, and there should be a poll popping up, is, does your government, and I said government you primarily work with, because some might work with within regional organizations, of course, but does the government you primarily work with return children in migration or not? Ooh, I see everyone. But never unaccompanied children. So yes, I think we've got 13 responses now. More might be coming in. But I do think this reflects the reality that many people see on the ground. On the one hand, children are returned, in the sense that children, whether in families or unaccompanied, do receive return decisions. But then, of course, when it comes to effective returns, unaccompanied children in several countries are not returned until they become of age. So maybe go back to the slide, thank you. So on the one hand, there's a very limited data on the number of children in the EU anyway, who are in migration on the one hand, and when we say in migration, there might be numbers on the number, data on the number of asylum seekers, but there are very little data on, for example, children, disaggregated data, I mean, in other procedures or undocumented children, or the number of children in return procedures, of course. Maybe an important thing to know, or an important data to jot down, is that in 2017, Eurostat reports that 79,365 children have been found to be irregularly present on EU territory within 2017. That does not mean, of course, that all these children were deported, for example, of the country, or effectively returned or left the country. It's only the number of children that were found to be irregularly present. Then one of the key issues that we need to talk about when we talk about what's at stake is, of course, the important impact of finding a durable solutions and of what happens to their future, of course, for children's lives. So there's research done by several organizations. I'm just going to highlight two of them on how children found their lives to have changed after being returned on the one hand to Kosovo, and that's in research done by UNICEF. On the other hand, returned to Afghanistan, that's research done by Save the Children. So for example, of the children interviewed by UNICEF that were repatriated to Kosovo, 1 in 3 children had symptoms of post-traumatic stress disorder, 44 children reported symptoms of clinical depression, and importantly, 1 in 3 families re-migrated within a year due to discrimination in access to services, lack of housing or income. And on the other hand, when we look at the impact on children returned to Afghanistan, 3 in 4 children said they did not feel safe during the return process. And more than half reported instances of coercion or violence. And that is very important because that means that not only there is an impact, of course, after, but there's also clearly a lot of work that the returns procedures that are in place are not child rights compliant at the moment. So I already mentioned the fact that a return without a prior best interest procedure are common practice throughout the EU, especially for children in families, of course. Some states, as I mentioned before, do have these for unaccompanied minors. And except for these reports and researches done, let's say for certain countries, generally there is little to no monitoring of the situation of children after return. Although, of course, some countries, there are very noteworthy practices that I will not go into now, but that are, for example, in the position paper, which we are going to mention later. With what's at stake, it is of course important for member states to engage with the issue for several reasons. On the one hand, it is about human rights, and it is thus there is a danger for human rights violations on the one hand. On the other hand, there's also a group of children or young people or families that member states issue return decisions to, but they cannot effectively be returned. And we believe that the durable solutions procedure and effectively analyzing the best interests of the child within those procedures would or could decrease the number of those quote-unquote unreturnable people. Because, of course, when a durable solution is found and effective, a real durable solution, then that would simply not happen. So with that in mind, I'm going to pass the microphone to Rebecca, who is going to talk about, of course,
stepping back a
what
little
law
bit,
has to do with migration.
Because, of course, many of you are interested in this issue and talking with your local and national stakeholders and policymakers, and some of you may already be involved in some of the EU work. But if it's okay, let's just get back to basics for a moment. I mean, we all know we've just been through a European election, and migration has been one of the big issues on it. But what in fact has EU law and indeed EU policy got to do with migration? And it's important to be clear on this, because the EU can do certain things and the member states can do certain things. So obviously in our advocacy, we have to go to the right targets at the right time. So at EU level, there are rules on international protection procedures. So that's the asylum and subsidiary protection rules, and the trafficking directive, which addresses when people have been through trafficking situations. And in particular, there are provisions in the trafficking directive which ask member states to establish durable solution procedures for, to find durable solutions rather, for children who've been trafficked. So that's on whether someone can get asylum or whether a child who's been trafficked, what's a durable solution for them. There are certain EU rules on other legal migration procedures. So, for example, there are common rules on family reunification around Europe. But there are member state rules on other types of migration status. That can be humanitarian status. It can also be certain legal migration rules. So member states have a lot to say on who can come in to their countries and get jobs, etc., with legal visas. And the EU has less to say on that. But the EU Return Directive does establish common rules, which mean that if under national law, a third country national, to use the EU text, so a person from outside of the EU, a person who is not a citizen of an EU country, if a person is in a member state and they are viewed as legally staying, for example, because they're a rejected asylum seeker under the EU rules, or they don't have a national visa, then the common EU rules say that the member states must either, take a return decision or, apply a national rule to give a status. So the EU rules discourage illegally staying nationals, as they put it, to just be left in the countries. Now, what does that mean for us? In the Return Directive, which was a very contentious directive, there were rules and safeguards, and there are rules and safeguards, I should say, for everybody, and in particular for children, and more specifically, the safeguards relating to children really focused on safeguards for unaccompanied children. So children and families are relatively invisible, as it were. There are rules that families should be kept together, and pre-return children should have access to education. But in relation to the decision itself on whether return should be ordered, there's very little specific rules in place. Whereas for unaccompanied children, there is a specific rule which requires assistance to be given to the children. Now, that being said, the best interest principle is in there as a general provision. So in theory, all member states should be taking into consideration the best interests of all children under the Return Directive. They just don't, the directive doesn't specify how that is to be done. So obviously that gives rise to a lot of different practices between member states. And I think as we see, and as Tisha has described, very limited safeguards for children in families, and even for unaccompanied children, just very general safeguards. Sorry to get technical, but it's just important to set that scene. Moving on, I've covered some of this. What's the framework? We have the EU Return Directive, and as I said, member states have to take account of the best interests of the child. As I said, there's very little detail in the directive, but the Commission put together an EU Return Handbook, which offers guidance to member states on how to undertake these return procedures. And it has a section on return of unaccompanied children, but not much on children within families. Now, what is good is that in the section on unaccompanied children, the handbook specifically talks about the need to find durable solutions for children, which means that return can be one of those options, but isn't necessarily the right option. One should look at the best interests of the child. And that position was taken up and emphasized in a document, a very important policy paper called the European Commission Communication on the Protection of Children in Migration, which was adopted in 2017 by the European Commission. And that sets out actions and priorities for both the EU and the EU agencies and also the member states in relation to children in migration. And again, it emphasizes that states should be looking for durable solutions for children in migration and therefore looking at their best interests. And this position was also recognized in the Council conclusions. So the Council conclusions are the conclusions of the member states when they come together at EU level, and they also took that view. But there is, at the same time as the Commission communication on children and migration was being adopted, other pressures were coming to play. And there was increasing pressure on member states to, in fact, increase return levels. And this was, of course, in light of the numbers of new arrivals and sometimes the temptation to find simple solutions to what was seen as a mass influx of people. A simple solution being, let's return them and return them fast if we can. So despite the communication on children, encouraging people to find durable solutions, other policy documents and other policy discussions at EU level were saying, let's increase returns. And they weren't talking about special safeguards for children, and certainly not for children in families. And there was a revision of the Return Handbook guidance, which encouraged member states to increase returns and gave suggestions on how to streamline procedures and streamline safeguards as well. And although many of the NGOs expressed their concerns, and IGOs at the time, and said, look, you really got to keep a focus on safeguards for all children, nonetheless, the revision didn't include further thinking on children in families. But not only was the Return Handbook guidance revised, there was then a proposal to revise the Return Directive. So now we find ourselves in a situation where the member states and the European Parliament are coming together at EU level to negotiate new rules on return based on a proposal from the Commission. Now, that, nothing much has happened in the negotiations because of the elections. And again, we'll see what happens in September as the new Commission and commissioners come into place and the new MEPs take up their seats in Brussels. But that proposal is on the agenda, and let's see with what enthusiasm the political debate goes to it. But again, obviously a lot of NGOs and IGOs looked very closely at that revision, and there were real reasons for concern about the direction things were going in. There were provisions that promoted detention. There were provisions that could read that, okay, if you find a child doesn't need asylum, then you can very quickly impose a return decision. And of course, that was a concern for anyone looking at child rights, because a child may not have a claim for international protection, but there are other grounds which might suggest they shouldn't be returned to their countries of origin if there are other types of risks. And of course, that's the heart of the best interests procedure. That's what the procedure is there precisely to look at. There were also rules on increasing detention if someone was seen to be at a risk of absconding. There were also more increased, or abilities to have faster border procedures, again, without really looking more carefully at what should happen to a child in a border situation. So that is why we, a number of organizations in Brussels, initially came together and said, let's look at this closely. And I'm now going to hand over to Letitia, because that work, which has been going on for quite a long time, is coming to fruition finally.
Yes, indeed. So as Rebecca said, there was many concerns within the NGO and INGO world and UN agencies, of course. So there was a concerted effort which has been going on for, as Rebecca just said, a while, and very much inspired by that situation. And there was, for us, very important to connect the different experiences and the different, let's say, expertise from both UN and NGOs, and to build on past studies, reports, and initiatives. But also, and I think that is very important, to provide concrete and practical recommendations on every aspect of a durable solutions procedure for all children in migration. And I think that is very important to know that we, of course, look at all children in migration and not only one specific group of children in migration. This Saturday, and I really mean this Saturday, 2 resources will be launched. On the one hand, the guidance to respect children's rights in return policies and practices, and on the other hand, a position paper on called Durable Solutions and the Best Interests of the Child in the Context of Return Processes. And I'll quickly go into the similarities and differences, but if you want to receive the email that we'll be sending out with those documents, please do just note down your email address in the chat box so you can be sure that you receive it. And otherwise, it will also be put, of course, on the PICUM website, but only on Saturday, so you would not find them right now. So just add your email address to the chat box so we can send you those 2 resources on Monday, probably. So 2 resources. On the one hand, there's the guidance, which is very much a technical document. So it is produced by several UN agencies. When I say several UN agencies, I mean UNICEF, OHCHR, and IOM, and several NGOs, which are ECRE, Save the Children, PICUM, and Child Circle. And why is it both UN agencies and NGOs? Is of course because of that concerted effort to work together in depth. And the technical document, the guidance, is very much for policymakers and policy implementers, and of course for advocates, people who advocate for the rights of the child in migration. So that's the one resource. We'll go a bit more in depth in that, so that really develops the whole durable solutions procedure and the safeguards and the different elements that those should have. Then on the other hand, there is a position paper which is developed by NGOs and is signed off by a wider range of NGOs, and which, let's say, summarizes the guidance document, but does not go in depth in the technical or not all the technical aspects. And that is for several reasons, but mainly because the aim of that position paper is different. It is for advocates, it is for a wider public, of course also for policymakers, but it's much more a position of different NGOs vis-a-vis and less of a technical subject or document, let's say, to be used by people involved in the technical side of durable solutions and best interests of the child. So then, so just to make clear, when I talk guidance, I mean the technical documents. When I mean position paper, I mean the, let's say, less technical documents, which go, of course, hand in hand. So the goals of the guidance was keeping in mind the frame or the situation Rebecca was mentioning and describing. It is, of course, important to reframe the discourse that is that exists or that has evolved from a drive for return decisions to finding durable solutions for children in migration. Because that is, of course, not the same, and the goal should be finding durable solutions for children in migration. And also seeing as children and families have been, have received, let's say, a less strong framework, legal framework for protection than unaccompanied children in the past, to both address both groups, both unaccompanied children, but also children and families. And then thirdly, of course, to provide clear guidance, and that is really why the guidance document is so technical, because it needs to go from the beginning, the moment the child is identified, to the implementation of the durable solution. And of course, when you talk about durable solutions, Rebecca is going to go into it a bit later, we talk about of course, about three, which is integration, resettlement, or return. Quickly speaking, of course, because it's they are, well, Rebecca will go into it. Then quickly, there's a quick poll. I just mentioned quickly durable solutions, but maybe answer a question to you. What is a durable solution according to you? Of course, for children in migration. I don't see any answers yet, so I guess everyone is typing very developed and detailed answers. Okay, I'll give you 10 more seconds before we go into the understanding of the guidance document of a durable solution. Okay, thank you. Going to end the poll. So if you weren't able to finish your definition, feel free to share it in the chat, of course. So why is it important to talk about terminology? It's because, of course, we found that for advocacy, as I mentioned in the beginning, terminology is crucial, and it is crucial to coin that the definition of terms correctly. So just quickly, within the guidance, we talk about durable solution and not sustainable solutions, for the simple reason that European policy documents talk about durable solutions. So since this is a guidance document mainly directed towards EU, we of course use the term durable solution. So this is just a definition verbatim from the guidance document. which says that a durable solution is one that protects the long-term best interest and welfare of the child, which I've also seen in several answers, and is sustainable and secure from that perspective. The outcome should ensure that the child is able to develop into adulthood in an environment which will meet their needs and fulfill their rights as defined by the Convention on the Rights of the Child, and will not put that child at risk of persecution or serious harm. A secure and long-term resident status is vital to ensure that children in migration access all of their rights, including their rights to well-being and development. A durable solution may involve integration in the country of residence, or resettlement or reunification with family members in the country of origin or in a third country with support. And of course, how to identify the durable solution is developed more in depth in that guidance document. Because of course, governments have a responsibility to investigate all options and not simply one of them. All options and the implications of those options on the child to identify the best interest and of course before making a decision. If you have any questions, add them to the chat, of course. Of course, who's a child, anyone under 18, and important, the best interest procedure, which is of course developed in the guidance document, is a procedure to identify durable solutions for a child based on the consideration of their best interests as soon as possible after their identification. And the procedure must include formal and specific safeguards to ensure that the best interests of children are properly examined before any decision on return is made, and it should be based on a documented procedure to examine the best interests of the child with procedural safeguards. Sorry, there's a lot of tongue twisters in there. And again, as I said, the details of the procedure are in the guidance document, but also in a helpful diagram which Rebecca will go over now.
Okay, so we know you can't probably read this diagram. So it's there to show you that in the guidance, and when we were working out the guidance over many, many meetings and many consultations within our organizations, and then onward consultations with a lot of different organizations, including the Commission and different EU agencies, and indeed member state authorities and stakeholders. So we've shared the document and the guidance and the procedures. And this diagram is a place where you can see that there is a specific pathway conceived of. So on the left-hand side, you can see the flow of the procedure. Where does it start? When you have, if a state identifies a child as irregularly present in the territory, or if a child is in the system already, and the state is about to kind of issue a negative decision on a residence permit or on international protection. So any child, whether they're unaccompanied, separated, or with family. And what's important to say is also, if the decision applies to a parent who has a child on the territory, or we're saying in all those circumstances, you go into this second, the light orange or the tanned part of the diagram, and you go into what we call a best interest procedure to find a durable solution. So before you take any decision that could lead to the return of a child in the family or a parent of a child in the territory, you need to have a procedure where you will examine the best interests of the child. Now, I'll just press pause because many of you have come across best interest determination terminology before, and all of the terminology we use is explained clearly in the guidance. So here we talk about a best interest procedure. And that means that, as Letitia said, there's formal individual procedure. It involves independent and impartial decision makers who don't have a conflict with the a conflict of interest with the rights of the child. It should also be multidisciplinary, and very importantly, because it's not always the case now, child protection actors should be involved. Now, we know, of course, that some states do accept this and try and achieve it, in particular in relation to cases involving unaccompanied children. Some states already have what looks like a best interest procedure. In cases involving children within family settings, a lot of the times you'll find that the assumption is, of course, well, the children are with the parents, and the parents will take care of the best interests of the child. And of course, the whole point of this discussion is that parents will not always be capable or in a situation where they are able to take care of the best interests of the child, particularly if they're returned to difficult situations. Sometimes the situation of a child within a family isn't looked at, and therefore when authorities are saying, okay, we need to return children, they're not looking at maybe very acute health needs of the child, or, as we all know, education possibilities for the child. The child might be in the middle of a school year, and the return decision simply takes place in the middle of a school year, totally disrupting the child's situation. So that procedure should be in place for all children. But of course, the extent, it relies on information. You need to get information on the situation of the child. The guidance is very clear that the extent of the procedure and the extent of the information needed may vary depending on the complexity of the case. Because, of course, we were aware that authorities looking to take decisions may say, gosh, we cannot possibly have a very heavy procedure in place for everybody. That just means we won't be able to take decisions. So we were acknowledging, no, we specifically designed a procedure that should be possible. It should be possible to have it in place. It's not too difficult to ever operate or to ever reach a conclusion. And the guidance goes into detail on that. But I really want to emphasize that because our goal was not to make it impossible to take decisions. The default was not, it's always in the best interest of a child to stay where they are. The point was precisely that, one has to look at the options, and it may well be that return is, in some instances, in the best interest of the child. And a procedure should make that conclusion something one can reach, but also that is something that can be implemented properly with the right safeguards. And if you don't look at the child's situation, you can't implement it properly. And if you don't implement it properly, it simply may not be sustainable, or the impact on the child will be way too heavy. So having come to a decision on either local integration or returning or integration in another country, as you can see, that's provided for in the third box. In the final box, that decision should lead to implementation. We've noted that voluntary departure, so where people leave in accordance with a return decision, but leave in a voluntary way, is something that should be supported. If people can't leave on a voluntary basis, or don't leave on a voluntary basis, we've provided in the guidance, or the guidance provides for a review by the decision makers again of the situation of family, because sometimes things happen and circumstances change. And that review may lead to a new removal or an alternative durable solution being put forward. And you'll see that appeals are provided for in that kind of streamlined way. Now, finally, if there is to be a removal with safeguards, and I think you can all imagine that's very sensitive territory, again, the guidance goes into detail on what kind of safeguards have to be in place to ensure that that is child rights sensitive. So this illustration is out there, but it has to be read in conjunction with the guidance, which of course goes into detail on all of these moments and all of these safeguards and all of the alternatives. And although it may look complicated, it is, we believe, eminently practical, and it does base itself on some good practice at member state level. So, you know, there are examples of when this is actually being achieved in practice. So again, that will be winging its way to you if you would like it.
Rebecca, sorry.
The policy paper.
Sorry,
yes.
I just wanted to add that
Please go ahead.
guidance document. When we talk about integration or integration into a third country, it's not developed as in-depth in the guidance document because those procedures, there's a larger body of work when it comes to child rights in integration or in integration in a third country. But when this whole process started, there was little to no body of work when it comes to ensuring that decisions of return are made in a child rights compliant way. So just to highlight that that is the reason why this aspect is of course much more developed in this specific guidance document.
Thanks, Letitia, and also to say, this goes back to the basics that we talked about at the beginning. And I'm sorry to be technical about this, but the fact of the matter is, it's of course EU law cannot, you know, it isn't able to put in place rules that say when people can stay or not, except if it relates to international protection needs, or in the case of trafficked children, the law provides for a durable solution. So it's up to member states to decide in other circumstances whether someone is illegally staying. So where EU law intervenes again, it's specifically on return decisions. So that's why very much the guidance has return as the starting point. And we're saying no, you know, even at EU level, return, when we're talking about children, has to be reframed in terms of a durable solution framework. So member states, this is where national and EU law should come together to have a durable solution that works and that fits in with the EU return framework and with the national legal framework. So sorry to be technical, and don't hesitate to ask questions. We won't probably have time to deal with them all here, but I think that's, you can appreciate why the guidance runs to 20 pages. And all of that, of course, is very important to the advocacy work, because it means that, you know, advocacy at national level on returns, on detention of children before returns, has to be, to a large degree, at this moment in time, directed at getting your governments to take certain positions in EU discussions. And that's a really important thing to take away from this call. And again, that's why it was so important to have this guidance and this policy paper available now and available to everyone at national level. So we can start this conversation and support national organizations and practitioners in the work they do at national level to shape change and shape progress in the future. We had, in the policy paper, you will find 6 key steps which will help you describe to stakeholders and to policymakers exactly what's in the guidance. And I think, and Letitia, I think you may have moved forward in the slides precisely because we've probably covered some of that and it overlaps with what I've said previously. Or would you like to go into those policy messages quickly or briefly?
It's interesting to, I see many people have given their email address, so I think it's important to look at the position paper for those 6 steps and the key messages, guidance document for the technical, and then maybe look at how this can support your advocacy and keep, 5 minutes for Q&A.
Yeah, exactly. So, I mean, being very quick now, the Initiative on Children and Migration, which has a website, and we invite you to look at it, is precisely about bringing together the experience of migration organizations and professionals with child rights organizations, child protection practitioners, and stakeholders. So really, when we look at return and deportation and detention at national level, and indeed at EU level, we often hear the voices of migration organizations. And what we found it best to do is to work with all the stakeholders. But that can be a lot of work. Because we have quite a way to go in creating common understandings exactly of what a durable solution is. But we would suggest that at national level, this is exactly what you should do to be effective. Create the common understandings, and many of you have already done that. Reflect the experience of practitioners and professionals involved. One of the dangers is often people talk about this in very abstract terms. Detain children and families, send them back, but without really knowing the realities of that. The guidance in large part is really suggesting you take a big case management approach, that governments should work with children and families to really examine their circumstances and make it sensible for them to find a future path. So again, we really encourage you to talk to the professionals involved. Be aware of the national and EU policy opportunities, and we've already talked about that. And finally, consider bringing the voice of different actors to the advocacy. I mean, sometimes the most effective advocates for proper procedures before any deportation can take place are the health professionals, the education organizations, and the child rights ombudsman. And I'm sure you're all very familiar with that. But to those less familiar with the advocacy, really think about reaching those organizations who have a different kind of voice. And I'll leave it at that. Letitia, can I turn to you for added words and maybe some perspectives from PICAM, or just wrapping up on the discussion?
I think depending on your advocacy, sorry, I'm suddenly in a very loud space. Depending on, of course, the target of your advocacy, I do think these two documents, resources can support that work. Voilà, I think maybe we're 53, so maybe we have, 54 after 2. So maybe if you have any urgent questions, do type them up in the chat, and we'll try and answer them concisely, but with nuance, if necessary or if appropriate. Comprehensive, I mean. And if not, if no questions come to you right now, don't hesitate to contact us. I'll immediately show you our 2 email addresses. And as I said, the 2 resources are being launched this Saturday, and then on Monday, if you share your email address to us or to Child Hub, you can receive it in your inbox for reading and reflection.
Thank you very much. Maybe we leave a minute more for everybody to ask questions if you need anything. Before you all go, we will have a few, 2 more polls for you. And also, I just wanted to emphasize that it is possible to receive a certificate for attending this webinar. All you have to do is write us on this email, info@childhub.org. You can see it in the chat. Also, if I see many of you shared your emails here in the chat, but I imagine not everybody is comfortable with sharing email in a public chat where there are people you don't know. I just assume it could be an issue for somebody. So feel free to write us on this email if you would like to receive a document in the documents that Letitia and Rebecca discussed today, and we will forward them your request. This presentation that you saw will be available after the webinar on our website. So you can see, you can take emails there from Letitia and Rebecca and contact them directly if you have any questions. But if you prefer, you can also write if you have any questions for them on our info email, and we will forward them the questions and make sure that you get an answer. So this is all from our side. Maybe just a quick note that now the poll is on the screen. Please let us know how this webinar was for you. And also we offer you an extra poll to tell us if you have any other feedback. So if you know anything that you like today or that you would like to improve, if you have any particular topic related to what you've heard today that you think would be worth discussing further, or any interesting name for a speaker on your mind that you think you or your colleagues would be interested to hear, we are open for your proposals and we will do our best to meet all your needs. This is practically the aim. So since I see we don't have any questions, I would like to thank everybody. Thank you for joining us today, and thank you very much both Letitia and Rebecca for the discussion today. I think it was very useful, and probably you can expect a few questions once people read the document that you will share with them. So I think we should be prepared for this. Thank you all very much, and I look forward to seeing you on our future webinars. Goodbye, have a great afternoon.